A very good morning. Mr. Pradeep Rai is a senior advocate in the Supreme Court of India. Mr. Rai, one of the extraordinary qualities of Justice Venkatachaliah, it is said, is about encouraging young lawyers at a time when legal profession is somewhat not as democratic and inclusive it ought to be, at a time when more and more new generation of lawyers who are first generation lawyers who are entering into legal profession. A man like Justice Venkatachaliah was able to go beyond the traditional approach to looking at only those who have advanced standing in the legal profession, but is constantly encouraging young people. Please reflect a bit on that, and of course, in general, his contributions as well.
Sir, actually, Honorable Justice Venkatachaliah, he started his career as a police officer. He was the IPS officer because his father wanted him to join police service prior to joining legal fraternity. But he did not like it and he left. He joined the profession. There are few examples that one, he is the founder of National Judicial Academy, so that reflects that how much he was into the education, not only for the younger generation, but also for the judges. When he became judge of the High Court, he was third in seniority when he was picked up for Supreme Court, because those days, the then CJI, Justice R.S. Pathak, he was in a visit of different high courts and he was trying to find out good talents. So one opinion from almost entire high courts of South was that nobody is better than Honorable this gentleman. When then Chief Justice Sen, he requested him to meet, and he said that why don't you call on the Chief Justice of India? He said, no, I am not in habit of calling on anyone, and he did not meet him. Thereafter, when he was even being picked up for the Supreme Court, again the then Law Minister Shiv Shankar requested him that, sir, you should just call on Honorable Prime Minister Rajiv Gandhi. He said, no. He said, should I communicate this to Honorable Prime Minister? He said, yes, of course. But he was picked up and he received a call from our former Attorney General, then Attorney General, Mr. Parasran, and he joined the Supreme Court. The one fact which is very important and which is a lesson for almost entire fraternity, that he did not enter into anything after serving as Chief Justice of India. He said that once I have been Chief Justice of India, I have no business to accept any other assignment. For judges, it's all right, but for CJI, it is not appropriate. When he was again offered as the chairman of National Human Rights Commission by then Prime Minister Narasimha Rao, and fortunately, I had known him since those days, and I have seen him conducting, he said that I don't want to accept this assignment, because I have made a commitment that once I have served as Chief Justice of India, I am not going to accept any assignment. But then Prime Minister personally called him and sent Padmanabhan Nabaya, the Secretary, Home Secretary, and he said, no, I want to meet him. Prior to rejecting this offer, he should meet me once. So he met him and he said, sir, if you join this, if you accept this assignment, at least you can serve. Even if you can save 2 lives, it's like a great thing. Sir, he is fond of reading. And he says that every day you talk about any subject, he has some special knowledge. Even in artificial intelligence, I remember 6 years back, there was a conference in Bangalore. We were participating. When it was raised that, sir, do you think that this courts will function like this only? He said, no. I can see that the courts are functioning virtually. And there were 2-3 other former Chief Justice of India. They said, sir, we are not going to buy this. He said, you see, one judge will be sitting at one place, another judge will be at other place, lawyers will be at different places. Litigants may also observe from there. This is going to come. And sir, unfortunately, this COVID came and those predictions, what he made publicly was found to be correct. I will say at last one thing, that he was fond of education. एक फिराक की लाइन है, वो मैं वेंकटचलैया जी पे कहता हूँ कि आने वाली पीढ़ियाँ जो हम सभी लॉयर्स की हैं, हम लोग को नाज होगा कि हमने वेंकटचलैया जी को देखा था. तो मैं इसके लिए बहुत-बहुत आपको धन्यवाद करता हूँ कि बहुत अच्छी किताब आई आप.
Thank you very much, Mr. Rai, for recounting on some of those very, very unique anecdotes as well. Let me say this, that I was so privileged to be at the National Human Rights Commission when he was the chairperson. Just when I graduated from Campus Law Center in 1997, I didn't become a lawyer. I decided to join the National Human Rights Commission. So I saw firsthand what he did in NHRC as chairperson during 97 and 98. Many people may not know, but because of his personal intervention, India was able to sign the Convention Against Torture. He personally engaged with the then Prime Minister and the Home Minister. But the tragedy is, even after India signing the Torture Convention during his tenure, we have still not been able to ratify it even more than 2 decades later. Another major contribution he did at NHRC was about manual scavenging. The Manual Scavenging Act had already been passed, elimination of manual scavenging. Unfortunately, it was not notified. He again took efforts to ensure that the act is notified. He worked on right to health, maternal mortality and anemia was a major problem. He was at the vanguard of it. In some ways, what he did is lay the foundations of the National Human Rights Commission, which was established in 1993 only. And he, of course, was one of the earliest persons who assumed the leadership. So truly remarkable for him to do that. Let me quickly move to Justice Banerjee. Justice Banerjee, we are indeed talking about the legacy and the contributions of Justice Venkatachaliah. One of the things that comes very strongly is his deep sense of independence, autonomy, and consciousness of his commitment towards speaking truth to power. A quality that you quite rightly said in the form of integrity should be assumed that judges ought to have. Now, without going into details, it is not an exaggeration to say that the issue of integrity, independence, autonomy of judges, even at the highest level, has come to serious questioning and scrutiny in the last several years. My question to you is that, what would you like to say about that trend that is developing, and how do we address it, and what can we learn from the life and legacy of Justice Venkatachaliah?
It's okay. Justice Venkatachaliah is a role model for any judge. I've just said that. Now, so far as independence is concerned, I think independence and integrity, so far as judges are concerned, are interlinked. If a judge is not independent, then he is not going by the oath of office which he takes. Again, I repeat, the basic qualities of a judge are his independence, his integrity, and his impartiality. Justice Venkatachaliah had them all. That was also the advice which he gave to judges. In 2014, he had come to Calcutta. By that time, I was a judge. He had come on the occasion of the formal release of a book on Justice Ashutosh Mukherjee, written by Mr. Sudhish Pai. On that occasion, I had the privilege to meet him and actually share the dais with him as one of the speakers on the occasion. He always advised judges to be impartial, independent. Now, if you say that there is a perception that there is lack of independence today, I can only say that it is unfortunate. But I think judges are by and large independent, at least persons I've worked with. we even have one of the former Chief Justices sitting right across, and we have seen him as a very, very independent judge. There have been other Chief Justices also and judges who are independent, if there is lack of independence anywhere. But there is also one thing. You can't always go by press reports, social media reports, because what does independent mean? Independent doesn't mean that you become the leader of the opposition. And independence doesn't mean that you go by what the government does all the time. Independence means that you decide a case on its merits. If the government is in the right, then you hold in favor of the government. If the government is not in the right, then you hold against the government.
Absolutely, ma'am. I entirely agree with you, and I think the hallmark of a great judge is to be able to function autonomously and independently, but without fear or favor for anybody, be it the government or the opposition.
But then there is also another thing. Justice should not only be done, but it should manifestly be seen to have been done. So if a judge is too close with any political dispensation or persons belonging to any particular dispensation, then if the judgment goes in favor of that political dispensation, then, the principle of justice should not only be done, but manifestly be seen to have been done, gets breached.
Absolutely.
There are exceptions when you have to interact in the course of your official duties. Because, when you're the Chief Justice of a high court, let us say, when I was in Madras, for funds, you had to approach the government. So once in a while, there had to be meetings. But these were very open meetings. These were official meetings. Other senior judges used to be there. Officials from the government also used to be there. But if a judge is meeting a politician on a one-to-one basis, then it sends the wrong signal to the people.
Absolutely, ma'am. Thank you so much for those reflections. Let me move to Justice Waziri, probably shifting gears a bit. So one of the things that many people outside the legal system, as in those who are not interacting directly with the judiciary, may not be familiar, is the extraordinary volume of work that our judges do. I mean, think about the fact that the Supreme Court of India produces over 1,000 judgments a year. If you look at counterparts in any part of the world, they don't do that much work. And the same thing holds good for high courts and other courts. So my question to you is that, and Justice Venkatachaliah, of course, was very conscious of the delays and the impact of it in the administration of justice system as well. So my question to you is that, how do we bring that into a more sharper focus within the administrative of justice system now, and to what extent today's advancements in science and technology can help us address some of those issues?
Considering our population, we are possibly the most non-litigious nation. Yes. But there will be, people will assert their rights. They'll ask for their freedoms to be upheld. As more and more the courts become accessible and they realize what the Constitution means for them. So if you look at the population to the number of cases pending, it's a very, very minor one. Amongst the various measures in which various judges have tried, Chief Justice have tried to find solutions, is also the solution by Justice Lalit, who's sitting here in his tenure, he tried to bunch cases together and finish off hundreds and hundreds and thousands of cases, which he did very, very successfully. Technology is, of course, there. Earlier, just moving of files would take so much time to bring the cases to the court. Now, with the e-filing and e-courts, things are much faster. So the time taken in actually getting the case to be heard is shortened. It is easier for litigants to be sitting at home or wherever they may be, for lawyers also to travel. But you look at the number of cases which are pending today, roughly 4.5 crores, if I'm not mistaken, somewhere there. But of them, a large number are check bouncing cases, your motor accidents. So these take virtually half the numbers. And in the other half, if you look at it largely, 65 to 70%, the government is the litigant. Now look at it, where is the meat of the case? Where is the meat of the matter? If you remove all these unnecessary ones, you really don't have much of a pendency, and the judiciary can very well take care of it. But if we are bogged down with simple things like ye kya motor accident ka chalans aa rahe hain, and the check bouncing cases, that suddenly the public thinks, oh, there's so many cases that will never get solved in a lifetime. It's true. There are cases pending for many years. But in the high courts, the chief justices and all the judges are trying to see that cases do not remain pending for more than 5 years. That's an effort being made. 10 years, 5 years, etc. So they don't lose their relevance. And I think technology is helping in a big way out there. No, we were talking about Justice Venkatachaliah. I remembered something just now. The gentleman, you know, you looked at him and he inspired you. You looked at him, लगता था यहाँ इंसाफ मिलेगा मुझे, यहाँ इंसाफ मिलेगा. कोई शक व शुबहा नहीं था. और यंगस्टर्स के लिए खास तौर पे, he personified equanimity and fairness both in personal and in public life. He believed that we must be circumspect in our personal affairs and in our public affairs and in interpersonal dealings or interactions. एक वाक़या याद आता है कि he said, you know, when he was practicing as a lawyer about 50 years ago, a litigant, his client gave him what he thought was the appropriate fee. He kept 2/3 and returned 1/3 of it, because he believed that the amount he retained was more than sufficient for the services rendered by him. That was the measure of the man, fair to the nth degree. And a person like that, when he occupies the position of the judge, it really reassures the litigant. As Justice Banerjee was saying, fairness is intrinsic. It has to be a part of the soul of that individual occupying the chair. They take the oath. But more than that, the person has to inspire that confidence in the litigant there. It should be seen from a distance. If the judges together, they make the court. जिस रोज लोगों का विश्वास हटने लगेगा, तो फिर मायने नहीं रहेगा उसका. Thank you.
Thank you very much, Justice Waziri, for those, I think what you said is so critical, especially for today's generation of lawyers and judges, about the exemplification of gracefulness both inside and outside, public and private. Baram, one of the things that I want to ask you is about the way the legal aspects are dramatically changing and how judges are asked to adjudicate on complex matters. Now, unfortunately, the legal training and to some extent legal education is not necessarily preparing them adequately for the dramatic changes that are happening in the world of law. Law and economics are having a greater impact on several aspects of litigation. So my question to you is that when you are looking from the standpoint of a lawyer and when you look at judges, how do you think we need to reimagine continuing legal education for judges? What ought to be the way the judicial academies need to prepare the judges so that they are better suited to address some of the new and emerging areas of law, because law has dramatically changed, and what lessons we can learn Because clearly Justice Venkatachaliah was ahead of his time, as you mentioned, when it comes to his role in advancing the arbitration aspects of ADR.
Yeah, no, that's a very critical problem. So in some ways, it's the opposite. I said, when you're a junior, soak in and be as broad as possible. And then, of course, at a judge's level, there's no question that you need the broad knowledge and you have the aptitude, you have the intellect, that's why you are there. But in today's world, let me take an area where I have spent a lot of time, so bankruptcy. I think for something like that, to have a bench which has had the benefit of some discussion, I think what we did there, we had colloquiums between the NCLT and NCLAT members and the practicing lawyers and people who were involved in drafting the law, just so that you could have a dialogue and explain to the judiciary what we are trying to achieve. And I think that was very, very helpful. And therefore, having specialization in those kind of areas, you know, as you said today, competition and bankruptcy and intellectual property, those areas to have that CLE and in an appropriate forum, because I know these are sensitive issues as well, is very, very useful. Because what has happened today, because IBC is getting so much priority, the regular company matters are suffering a lot. So we do need some kind of specialized benches as they have across the world.
Thank you very much, Bairam. Let me move to, sorry, please.
Your question was, what should the judicial academies do?
Yes.
The judicial academies should initiate discussions, which the National Judicial Academy does. They regularly have programs for judges of different levels, for the civil judges, for the district judges, and also for the high court judges. Now, there is one thing which all judicial academies need to do, they have been doing. Maybe they should take it a little further. You know, we talk about independence, we talk about integrity. But what exactly should be the norms? This is something which should be formulated jointly on a concerted basis, taking opinion of all stakeholders. Of course, the Bangalore principles are there. The Bangalore principles are there. Then you do have the full court decisions of the Supreme Court taken way back in the 90s. But I think with passage of time, a little bit of streamlining is necessary. Because the newly appointed judge, particularly a judge appointed directly from the bar, may be a bit confused. He may know that, yes, independence, impartiality, without fear, without bias. But how should he be behaving? To what extent should he be intermingling with the lawyers who appear in his court? To what extent should he be interacting with his former friends and colleagues who might be appearing before him every day? You know, these are areas which require discussion.
Well, thank you so much, ma'am, for those comments. I think all of them are important questions, especially in the context of a lot of young people entering into judiciary, and they may or may not be familiar with those principles that have evolved over the years. I'm conscious of time. We have another 9 minutes to go. So, Mr. Pradeep Rai, my question to you is that, you see, one aspect of Justice Venkatachaliah's contribution, which I think is quite remarkable, is the fact that he also remained a public intellectual. He not only confined his work as a judge, but the heart of his interest remains the true advancement of law, where even after judicial work, he continued to do so many other things. He was actually actively involved in the Center for Governance in Bengaluru. You mentioned about his contribution in the field of education. Much later, after NHRC, he took up the leadership of the National Commission to review the working of the Constitution. And quite remarkably, I remember very well that when there was some fears and concerns expressed by many members of civil society about the purposes of this commission, the fact that it was Justice Venkatachaliah who was chairing that sent a lot of, let's say, positive signals and assured people that the intent of that commission and the work of the commission itself is nothing but purely beneficial for advancing the law itself. And those reports are absolutely fantastic. So my question to you is that, essentially, how does a judge sort of evolve himself or herself into a public intellectual much after leaving the world of law and justice?
You see, Honorable Justice...
Yeah, you can keep it closer to you.
Yes. Honorable Justice Venkatachaliah, when he was Chief Justice of India, then and there also he worked on few things. Administrative competence, collegium system, on which I remember one incident when late B.L. Hansaria, whose son Vijay Hansaria is also senior advocate in Supreme Court, he was Chief Justice of Odisha, and he was very close to Honorable Justice Venkatachaliah. So once he visited Supreme Court and he said that you did not do anything for me despite all the competence that I deserve to be appointed as Supreme Court judge, you did not do anything. He said, if you deserve, you would have got. So if you don't deserve, you will not get it. Then he left, he went to Justice Ahmadi's room, who was then the number 2. And Ahmadi congratulated him that, Mr. Ansaria, you have already been cleared for Supreme Court. He said, no, but Justice Venkatachaliah did not inform me. He said, no, but we had cleared day before yesterday your name. So that kind of person he was. Other than this, what you were referring, he was such a person that if there is anything academic, intellectual, religious, and not only to Hinduism, about any religion, about any kind of writing, about any kind of concept or jurisprudence, he was such a person, and still he is such a person that he will like to interact, deal with it, and he keeps updating every day. If you talk to him, you will feel like that he is a scientist. Sometimes you feel like that he is an academician. Sometimes you feel that he is a man who is completely socially connected with each and every one. And sometimes you feel that he is a man who is expert of human behavior. I remember a few incidents when he was in National Human Rights Commission. We traveled a few places together. Even when he goes to a prison, he will try to see that how many plates are there, how many spoons are there, whether each and every inmate is getting one plate and one spoon, and by surprise to everyone that it was only 1/4 of the strength in the prison. So it was the great contribution of his that he did the prison reforms, he did educational reforms. He tried to, suppose a student writes a letter, like I, as a young journalist those days, when he was in Supreme Court, just by writing a letter, you could meet him. And he was such a person that he will try to educate you. If you are not agree with him, he will not mind. I am fortunate that recently there was a training program of mediation. I requested, sir, that, sir, tell me what we can do for the knowledge of lawyers and improvement of their academic skills and updating themselves. He suggested me that there are judicial academies which are working only 50 to 60 days in a year, despite all the infrastructure. Why don't you ask and request the Chief Justice to give you those facilities and use that, utilize that for the benefit of lawyers? I am thankful to Justice Ramanna and Honorable Justice Uday Lalit, who is present here. Justice Lalit, sir, especially for you. So, we requested Honorable Justice Ramanna and Honorable Justice Lalit that we need to be trained in the mediation, and especially we wanted Judicial Academy. I am thankful to Honorable Justice Lalit that he extended all the help, and our training program, which was the record 250, Earlier, only 50 mediators were there in Supreme Court, but those 250 mediators came in National Judicial Academy and Delhi Judicial Academy. I am thankful to suggestion of Honorable Justice Venkatachaliah, and I am thankful to the great efforts made by Honorable Justice Lalit for training those lawyers. Though we treat him from the bar only, he is I never treated him as an outsider. He has been a member of the bar. He is still our elder brother and our great support for all of us.
Thank you so much.